Court finally fixes date for judgment in Nnamdi Kanu's terrorism trial. After years of courtroom battles and legal twists, the Federal High Court in Abuja has at last fixed November 20, 2025 for judgment in the high-profile terrorism case against Nnamdi Kanu, the embattled leader of the Indigenous People of Biafra (IPOB). Justice James Omotosho set the date on Friday, November 7. After foreclosing the defense following Mr. Kanu's continued refusal to open his case. The judge said the defendant had waived his right to a defense by insisting that he would not proceed under what he described as a repealed law. Justice Omotosho declared that the court has given enough opportunity to the defendant as required by Section 36 of the Constitution and will not allow it to continue. He said the defendant has therefore waived his right. Earlier, the court had granted Mr. Kanu an hour adjournment to enable him to file a motion he claimed had been pending for days. For over a month, Mr. Kanu had declined to enter his defense despite repeated opportunities extended by the court. On Wednesday, the judge had warned that it would be his final chance to do so. The Federal High Court has been prosecuting the IPOB leader since 2015 on several terrorism-related charges, alleging that he instigated violent campaigns for the secession of Nigeria's southeast as the Republic of Biafra. Mr. Kanu, who holds dual Nigerian and British citizenship, has consistently denied the allegations, describing them as politically motivated. After the prosecution closed its case, the court directed him to respond. However, he dismissed his entire legal team, led by former Attorney General of the Federation, Kanu Agabi-San, announcing that he would represent himself. Multiple adjournments followed as the court kept the window for his defense open, but Mr. Kanu maintained that there was no valid charge against him since the alleged offenses were filed under a repealed terrorism law. Justice Omotosho had advised him to keep his gunpowder dry for his defense, but Kanu insisted he would first consult his legal advisors, that is Nnemeka Ejiofor, Aloy Ejimako, Maswe Okpara, and Mandela Umegborogu. The matter was therefore adjourned to Friday, November 7. When the proceedings resumed, prosecution counsel Adegboyega Awomolo-San informed the court that the day's session was meant for the defense to open its case, but Mr. Kanu told the court he had yet to file a motion saying security protocols by the State Security Service (SSS) had hindered his access to filing facilities. Justice Omotosho directed the court registrar to assist him, standing down the session for an hour. When the proceedings resumed, Mr. Kanu moved his motion, citing numerous constitutional and statutory provisions, including Section 6, 36, and 12 of the 1999 Constitution, as well as Section 165, 220, 274 and 311 of the Administration of Criminal Justice Act (ACJA). The motion sought to expunge his initial not guilty plea, alleging it was deceptively obtained in violations of his constitutional rights. He also prayed the court to set aside all previous proceedings and release him immediately, insisting that he was being tried under a non-existent law. In response, Mr. Awomolo declined to file a counter affidavit, saying he would rely on the existing exhibits before the court. Justice Omotosho, however, ruled that all pending motions, including those filed between October 29 and November 7, would be decided together at judgment. He stressed that he would not touch the substance of the case until the final ruling. When asked again to open his defense, Mr. Kanu declined, demanding that the court state the law guiding the charges. The judge replied that it was not his duty to explain the law, prompting the prosecution to reaffirm that all 7 counts had valid statutory backing. Mr. Kanu countered that the Supreme Court had struck out count 7 and insisted he could not proceed without clarity. Justice Omotosho then ruled that the defendant had voluntarily waived his right to defense and fixed November 20 for judgment. with no requirement for written addresses from either party. The case, which began in 2015, has seen multiple adjournments, changes of judges, and dramatic courtroom turns. It was halted in October 2022 after the Court of Appeal dismissed the charges and declared Mr. Kanu extraordinary rendition from Kenya unlawful. However, in December 2023, the Supreme Court overturned that decision, holding that while the arrest was illegal, it did not strip the Federal High Court of jurisdiction to try him. Since then, the case has been reassigned to Justice Omotosho, who took over in March 2025. The prosecution closed its case in June after calling several witnesses, prompting Mr. Kanu to file a no-case submission that was dismissed. Following that ruling, he listed 23 witnesses, including public officials and private citizens, in motion personally signed on October 21. He sought 90 days to conclude his defense, but when the case was resumed, he disengaged his lawyers and declared the charges worthless. He argued that the alleged offenses had no basis under any current Nigerian law, maintaining that no Western statute supports his trial. He later filed additional motions to have the charges struck out and to secure his release, all reiterating that his trial was based on a repealed law. Now, Nnamdi Kanu's decision to repeatedly refuse to open his defense reflects a calculated strategy of protest, one that challenges the legitimacy of the trial itself rather than its content. By arguing that the charges were brought under a repealed law, he has sought to undermine the case's foundation. The court's patience appear to have worn thin after several adjournments and procedural delays. Justice Omotosho's declaration that Kanu has waived his rights suggests that the trial has now reached its endgame. Legal analysts believe the November 20 judgment will be pivotal, either vindicating Kanu's legal defiance or reaffirming the state's authority to prosecute secession-related offenses under its counter-terrorism framework. Whichever way it goes, the verdict promises to reignite debates about the rule of law, political dissent, and federal power in Nigeria's democratic order.